Hi everyone, welcome again to one of the AACE Qatar section online seminars. I would like to welcome you again today for the seminar under the name of the Challenges to the Apportionment of Damages Principles in the MENA Civil Laws. So basically, it's a well-established principle in the civil laws of MENA countries that the contribution of delays by an employer can result in the reduction of liquidated damages on the contractor. So Dr. Walid Al-Namr, representing AACE International Greater Cairo section, he will explore the challenges with these principles in an engaging webinar hosted by us, AACE International Qatar section. So Dr. Walid, to present Dr. Walid has more than 25 years of experience in contracts and claim management, encompassing positions in various international project management firms such as Bechtel, Floor, and Hill International. He has also assumed several roles, including dispute resolution proceedings in construction projects, acting as an arbitrator, expert adjudicator, expert appointed by the tribunal, and party appointed expert, arbitrator, and dispute adjudicated board member. He is the country representative of Egypt of the Dispute Resolution Board Foundation, the RFP, Vice President of the Chartered Institute of Arbitrators CI Arab of Egypt branch, and also the President of the AACE in Egypt, Cairo section. He is the author of numerous papers and speakers in numerous conferences, seminars and webinars on the topic of construction contracts and claims. He is currently the contracts director of Hill International North Africa branch based in Egypt and assistant professor at the American University in Cairo. So I would like to welcome Dr. Walid, and the floor is yours. Dr. Walid.
Thank you very much, Saad, for this introduction, and thank you for inviting me to speak in this event about a topic that is actually very dear to my heart. This issue of apportionment of liquidated damages, especially in the MENA civil laws. I'll first start by an outline of the presentation. Basically, since this is an AACE international event, as you can see, it's a collaboration between AACE Greater Cairo section and AACE Qatar section. So then an introduction to AACE International is what we'll start with first, and then we will go into the apportionment of damages principle in the MENA region. And then we will go to challenges of the implementation of this principle, and then we'll have an open discussion. First, one thing that I just want to mention is that this is not a lecture where, a scientific lecture or anything. It's more of a discussion. I just want to share with you my point of view on a certain topic, which I feel very strongly about. And I would be very interested to hear your views and have a discussion on this point. And my only really hope is that this discussion would trigger maybe something thought on this principle, or may cause some kind of a change in the future. So let's start. First of all, AACE International. AACE stands for the Association for the Advancement of Cost Engineering International, and it's a US-based nonprofit association that has been serving the cost management community since 1956. As you can see, it's well established for well into the 20th century, and it's basically a cost management community. The cost management community that talks to this encompasses several disciplines, including not cost management, encompasses cost estimating, planning, scheduling, risk management, project controls, claims, contracts, you name it. And AACE has over 7,000 members worldwide and over 100 countries, and we have almost 90 local sections. And when we say local sections, so for example, Qatar section is one of those sections. Egypt or Greater Cairo is another, and all over the world we have several sections, and these sections actually are, you can say, I would say, like, wouldn't say that in competition with each other, but yes, there is some kind of a competition, and there's that actually intellectually is thriving. This is one of the benefits of AACE. Now, AACE is also known for its certifications. It has been certifying individuals since 1976. When we talk about certifications, we're talking, again, as you have seen with the principles, disciplines covered by AACE in cost engineering. You have the certified cost professional certification, the certified planning and scheduling professional, PSP. I think these are in the MENA region. These are the ones that are really well known. There is one that is, I think, very, very deserving of acknowledgement, which is the Certified Forensic Claims Consultant, CFCC, which for those who are interested, like myself, say, for example, in claims, especially in delay claims, and interested in being an expert, say, in this field, then this is something that for you. And this is a very challenging certification that is offered by AACE as well. So as I mentioned, Qatar and Egypt, they are just 2 of the 90 local sections of AACE International. I'm sorry, there's a typo there, which represents Egypt. Greater Cairo represents Egypt. Of course, Qatar is a different section. Here on this graphic, you can see we're divided into 10 regions all over the world. And this picture illustrates this categorization, and this picture is taken from the AACE website. Now, I think I've elaborated too much on AACE, but I just wanted to mention that tomorrow, inshallah, there is an event in association with the Arabian Gulf section, where I will speak at length about AACE and the assets of AACE and why it's beneficial to become a member of AACE from my personal experience throughout my years of being a member in AACE. So that we can talk about that tomorrow if you will attend. Now let's start with the material. So what is the apportionment of delay principle that I'm talking about? Or we call it the AOD principle. I will examine this principle from the civil codes, the Egyptian Civil Code and the Qatari Civil Code. And so basically in the Egyptian Civil Code, Article 216 mentions that the judge, or of course the arbitrator, may reduce the amount of damages or may even refuse to allow damages if the creditor, by his own fault, has contributed to the cause of or increased the loss. Okay. Notice here the word reduce the amount of damages, because that's really the core of today's presentation. In the Qatari Civil Code, Article 257, similarly, it says the court may reduce the amount or decide no compensation of the creditor contributes to or aggravates the damage through his fault. You'll find that they are pretty identical, very similar, and the cause is really that the Egyptian Civil Code was really the basis from which other civil codes in the MENA region was made. So you'll find this provision also prevalent in a lot of Arab civil codes as well. And the principle is very simple, is that if the creditor contributes to the loss, then the damages to which the creditor would be claiming would be reduced, okay, or not allowed at all. Now, how do we, what do these laws have in common? As I mentioned, this issue of reduction of damages or compensation, okay? So now we're talking about damages. So what is the relevance of this in a construction context? Basically, when we talk about damages, we are talking about 2 forms of damages, because we have normally the debtor is the contractor and the creditor is the employer. And depending, of course, on the obligation, but say for the contractor side, the damages that a contractor would be claiming due to an impediment or a delay from the owner, from the employer, is the prolongation costs, okay? Now, for the employer, the damages that the employer would be claiming from the contractor due to a delay by the contractor are liquidated damages, right? So if we look at this, read those laws in that perspective. So we have prolongation costs and we have liquidated damages. So with prolongation costs, what that means is that if the contractor is claiming for prolongation costs, for example, because the project has now extended for 4 months beyond the planned completion date, and the contractor is claiming for 4 months of prolongation costs, the contractor's damages or those prolongation costs would be reduced by the amount of delay attributable to the contractor. And that, of course, as you know, is the concurrent delay principle. And on that issue, I have actually contributed or collaborated in an article that talks about those clauses and how you can see that since the early 20th century, the civil codes really had the basis for the principle of concurrent delay. It was there from the civil codes. So as far as the contractor is concerned and prolongation costs are concerned, that makes perfect sense. And actually, since we are talking about AACE, and this is an AACE event, so if you look at an AACE has a lot of recommended practices, one of which is the 29R-03, which is the forensic schedule analysis, and it talks about the different, delay analysis methods and several delay analysis principles. And so it mentions here in the general rules that it talks about concurrency, and it mentions here, as you can see, that the contractor is barred from recovering delay damages to the extent that concurrent contractor-caused delays offset owner-caused delays, which makes sense. Of course, there are similar. There's a similar, reference in, for example, Society of Construction Law and other. It's just almost like an internationally accepted principle. So in that part, the law I think it's clear. There's no problem. Now, the problem that I'm discussing with you today is that latter part. This issue of that liquidated damages can be applied, but then they will be reduced later on. Okay, so this is really the principle that I wanted to discuss. And to illustrate this further, let me discuss with you this scenario. Okay, so we have a commencement date. Okay, and first of all, before I continue, I just want to also mention that if you have any questions, please make sure to insert them in the Q&A in front of you, so that we can, in the open discussion session, we can elaborate on these questions, and we get a chance to answer them. So bear with me in this example as I try to explain what I mean exactly by this problematic feature of reducing the liquidated damages. So what do I mean by that? There's a commencement date for the project, and of course there's a contract completion date. And let's say that the contractor that date was not fulfilled. As you know, most construction projects, that date is just might not be fulfilled due to several reasons. So in this case, it's not fulfilled, and the owner goes ahead and applies liquidated damages on the contractor. Now, the actual duration of the contract extends to a certain date, and then we have an actual completion. And then now the contractor takes this employer to arbitration, and after a while, the arbitration renders an award. Okay, and now the award of the arbitration would set a certain completion date for the project. Now, taking into account delays by the employer and delays by the contractor, so it sets this completion date, which, as you can see, is after the contract completion date. And then, when the tribunal sets this completion date, and it says, okay, so this is the reasonable date by which the work should have been completed, given delays by the employer and the contractor, whatever. So then they say, here they apportion the damages. So then, because the employer had applied the full damages, so they would say, we'll apportion the damages. At this date, the employer actually contributed with this number of days in delay, and therefore the damages will be reduced by this much, for example. Okay, now that concept really really perplexed me and troubled me so much. And I remember actually I have a dear colleague and a friend who is a well-known arbitrator in the Emirates and in Egypt, and I asked to discuss with him this principle of arbitrators reducing the liquidated damages because of the contribution of the employer in delays, And I remember we met at a coffee shop and we spent like 3 hours talking, and I still grappling with this concept, So the first thing I want to ask you before we go further is, do you see any problems with the scenario that I mentioned? Just if we can maybe have just a few thoughts. There's an anonymous attendee who mentioned, I believe in case of concurrence delay, the contractor granted EOT, so no liquidated damages applied, but also no compensation. So if you guys can tell me, okay, if you have any other thoughts, like, do you see any problem with this specific scenario that I mentioned? I'll try to put it again on the screen. So let me here, this is the scenario that I've mentioned. And as you can see here, so we have after the arbitration award is made, after the project is completed, then the tribunal decides how many delays or contribution from the employer. And from there, we have a reduction of the liquidated damages, for example. Okay, Bishman Samar, you can go ahead and you can I don't know if you can speak, but please put your if you can't, put your thoughts on the Q&A. Bishman Yusuf Berbar mentions, I think it's fair to be honest, whoever is at fault should be responsible for the damages. And Bishman Samar mentions that the liquidated damages shall be awarded from the extended completion date. The extended completion date, I think you mean, Bishman Samar, this date. Say for example, say if this is the contract completion date, and it's actually, say if it's an extended date for an amendment or something like that. If that's what you mean, then I understand, but I don't believe you mean from the awarded completion date, if I understand you correctly. Okay, so let's, I'll proceed. Thank you, Mr. So now I'll proceed with the presentation. And let me tell you, I'll propose to you two challenges to this reduction of liquidated damages that I've presented right now. The first challenge is that excusable delays mean that an extension of time has to be granted. I don't understand really the principle of having proportions of delay because of, say, there's a contractor's delay and there's an employer's delay, and therefore will reduce the damages. The way contracts are drafted is that if there's any excusable delay whatsoever, anything, any delay attributable to the employer, then there should be a time extension. It's not a partial thing. So if the employer contributed in any way in a delay, or of course when I say employer or engineer, then the contractor is entitled to an extension of time period. It's not something that is proportional. And then if the contractor is solely the cause of the delay, then liquidated damages should be applied. However, if on the contract completion date or the extended contract completion date, at that point in time, there were two delays, then by the concurrency principle, then there is an extension of time, but there might not be a compensation. Okay, but so sharing the damages, this is, to me, it's actually contrary to what the contract says. So for example, if we look at the FIDIC 2017 contract, and as you all know, this clause 8.5, which lists the factors that result in an extension, excusable delay. So you have here one of those factors clearly is any delay, impediment, or prevention caused by or attributable to the employer's personnel, or the employer's other contractors on the site. So basically what this is saying is that if there is any contribution by the employer to the delay, then the answer is an automatic extension of time, not a reduction in the liquidated damages. And actually, at this point, of course, it seems very obvious, but in my opinion, this reduction of damages runs contrary to it. And also, again, if you go to AACE International, and of course, this principle is also covered in the SCL, or it's an internationally accepted principle, simply is that excusable delays, that means, exists where there is contractual or equitable justification in a claimant's request for a contract time extension for relief from potential claims, liquidated damages, or actual delays. So basically what that means, again, if there's a justifiable cause for an extension of time, such as an employer's delay at the contract completion date, then the answer is an extension of time, because that's an excusable delay, not a reduction in the damages. Now, challenge number two, and that relates to number one, and that's a very critical issue, is that principle of prospective certainty. Now, what do I mean by prospective certainty? What I mean by that is that let's look at any contract in the world, any construction contract in the world. The intent of the parties in any contract form is the following, and I'll give you examples here from the FIDIC 2017. However, it's not. This has nothing to do with FIDIC. This has everything to do with common sense in construction contracts. So first of all, the time for completion is defined in the contract. The parties agree from day one when the time will be completed, the project will be completed. And then there's a clause that mentions that the contractor will submit a detailed schedule or a program that respects this time for completion. And there may be milestone dates, for example. And then we know that, okay, so the contractor submits knows the completion date, submits a program. And then if there are problems the contractor encounters while implementing this schedule or this program, then the contractor can submit an extension of time claim to say that I will not be able to complete the work by this date because of certain causes that have come my way. And of course, as we all know, there are regulations for submitting this time provision, this claim provision, including having time bars for notices and detailed particulars or supporting particulars. And I would here say that one of the core reasons for these time bars is not abusing the contractor, but it is prospective certainty, because you need to know promptly at the time how the completion date is going to be affected. We need to know at the time of the event, so it can be investigated, and then the completion date can be accurately and reasonably determined at that time. It's all to have prospective certainty. So the contractor submits an extension of time, has that right under the contract, and then if time is extended or the claim is rejected or whatever, but then there's a completion date is set in the contract. If the contractor does not meet that completion date, then you have liquidated damages. Okay, so in other words, what is this saying? So the contractor, represented here by this I, always has in front of him the contract completion date. He sees it right in front of him, so that the contractor can plan his resources. He can work towards achieving this date. Okay, there's a target in front of the contractor, and if he does not achieve this target that he knows very well, then liquidated damages are deserved, because of course that's a delay due to the contractor. If the delay is due to the contractor and the employer, no, then that completion date has to be extended, and the contractor knows what this completion date is, so that the contractor can work to achieve it. and be penalized for not achieving it. So, and that's prospective certainty. Okay. Now, what's with this apportionment of delay damages? How does that contribute now? How does that work in this scenario? Now, this is what happens. The contractor implements the work and submits an extension of time claim. Okay. So then what happens is that the employer or the engineer may not respond to this claim promptly, and I underline here promptly, and the contractor meanwhile is working on the site, and the project is completed and taking over certificate is issued, and then of course disputes are arising because you did not submit, you did not respond properly to my claim, you did not respond in time to my claim, and a lot of times the employer says, you did not complete the completion date of the contract, liquidated damages are applied, and then when liquidated damages are applied, there's a dispute, and the contractor takes this dispute to the arbitration, and the dispute is decided upon in the arbitration tribunal, and the arbitration tribunal would consider a certain completion date, taking into account the evidence that they have, examined or considered, and then they can decide on the reduction of the liquidated damages in a retrospective manner. So what I mean by retrospective manner is that, as you have seen in the previous slide in the beginning, the tribunal decide on a date that has passed, and then they say at this time there was this is the contribution of the employer for the delays, therefore will deduct the liquidated damages by this contribution. Okay, so in other words, the contractor here at the time, that's at the completion date time, really does not know what the completion date is. As in English law, time is really at large. There is no completion date. Okay. However, the completion date turns out after that to be something that is awarded in the past. Okay, so it's a retrospective date, and liquidated damages are apportioned and reduced. So basically, the contractor is, you can say, being penalized by having monies deducted from him for a completion date that the contractor did not know about, even if this deduction takes into account employer delays. Still, the contractor had no idea about this date. This is my problem. This is, I don't want to say my problem, but this is the issue that I'm really raising here in this webinar. Now, if we conclude, and I'll try to distill my conclusion in very key points. First of all, apportionment of liquidated damages, in my opinion, is contrary to the principle of extension of time. If there is a contribution by the employer, the engineer, to the contractor in the delay, then there should be an extension of time. There should not be a proportionality in the damages, a reduction in the damages. Okay. One thing that a very important thing that I did not mention in the previous slide when it comes to prospective certainty. What's the big deal about prospective certainty? The big deal is, and I have witnessed this, and I've actually written a paper on this, an AACE paper, is that when the contractor knows when the completion date is, then the contractor will work to that accordingly. That means the contractor can, inject into the project resources to try to complete this date. He's going to work double shifts. He's going to do all he can to complete the project by this completion date, even if the contractor does not agree to this completion date. Okay. Now, if the contractor does not know when the completion date is, and he has a right to know, as we mentioned, because that's the intent of the parties in any contract, then in that case, the contractor may be going at a very normal pace. In fact, the contractor actually may be going at a reduced pace because there's something called pacing And there's something called the contractor, even in our civil law jurisdictions, there's something called good faith. And one of the pillars of good faith or examples of good faith is that a party should not be unnecessarily spending costs, so there's no completion date. So why should the contractor spend even go with the rate that was actually planned? So there is the contractor believes that it's entitled to something. He did not get a response. Therefore, he's reducing the progress. That's what really happens, so prospective certainty matters. So when there's a delay by the employer or the engineer, then that contractually it entitles the contractor to an extension of time. Okay, so that's the first conclusion. The second conclusion that's very critical, very, very critical, is who is responsible for the lack of prospective certainty? Now, this is a crucial question. So we have one of two things, one of two answers. The first one is that, is it the contractor for failing to raise the claim on time? I've been involved in projects where literally the contractor raised, first of all, the contractor, for example, does not comply with an event by event, submittal of a claim, and the contractor submits a global claim, for example, sometimes 5 or 6 months after the contractual completion date, for example. Now that is completely, and you talk about prospective certainty, that's really a problem that the contractor has caused, upon himself. So in that case, the contractor is fully responsible, for that. There's no excuse. There's no excuse for that. So even if there are delays by the employer, the contractor failed to operate the contractual machinery, should have raised it in time so that there's prospective certainty. So in that case, if the contractor has failed to raise the claim on time, and when I mean by claim, I don't just mean a notice. I mean the claim, to know at the time of the delay event, what the completion date, what's the forecast completion date according to the contractor, so that it can be reviewed by the engineer and be determined. Or is it the engineer or the employer for failing to respond to the claim on time, even if a time limit is not in the contract? Now, with this question, I want to emphasize here something. I mentioned here engineer/employer, although the engineer should be in the FIDIC 87, an impartial entity in the 99, and a fair entity in the 2017, neutral, entity when doing a determination. But I'm putting them here because sometimes the engineer would prepare a determination, for example, yet it will be stopped by the employer because, it requires approvals or it requires whatever. So sometimes there's a contribution of this failure to provide a response to the claim. So if the contractor had submitted a claim before the contract completion date in time, and this was not responded to by the engineer or the employer, then that's really a very critical issue. And that is in itself, in my opinion, a delay that affects the progress of the work because of lack of prospective certainty. And it should not be taken lightly at all. And actually it should be taken, and this takes me to the next point, is that this should be taken into account in the MENA laws. So the laws, if we go back to the beginning of the presentation, we talked about the issue of, I quoted the Egyptian and Qatari laws when it comes to this point. And I think that in a construction contract, from a purely practical perspective, we should really look at this issue. Has the engineer failed in his obligation to provide prospective certainty, or is it really the contractor's failure? And then that should be assessed on a case-by-case basis in by the tribunal, so that a fair decision is made that really takes into account the circumstances of the project. It's not just, what I'm trying to say is, it's not just a like automatic okay, so we'll just reduce the liquidated damages and that's it. No, there's an effect for not determining the date on time, for not submitting the claim on time, and affects the progress, and therefore that has to be taken into account. Now, one thing I just want to conclude with, because for a long time, as I mentioned, I had talked to my friend, and I felt really alone in this thought. I was actually starting to have doubts, because to me it's just very, very obvious. So I came across this reference from Hudson's building and engineering contracts, and I believe everyone is familiar with this important reference in construction law, and of course this is the 13th edition, and the authors were discussing it from, of course, a UK perspective, and they were concluding that apportionment of liquidated damages is not runs contrary to the UK law. So this is actually saying it's not permitted under UK law. And granted, this I've come across this after during when I was writing that paper, and I was feeling very passionately about this subject. And I wanted to share with you what they said. The most important practical function of liquidated damages clauses is to confer a power to deduct damages immediately from the monies due to the contractor on interim certificate once the completion date or extended date has passed. And notice here the word immediately. So you have damages, if you want to apply damages, and on the next invoice after the completion, the contract completion date has passed, you apply the liquidated damages because of the contractor's failure to achieve this this completion date. Thus, the need for certainty, and see the word certainty here. Actually, this completely aligns with prospective certainty. The need for certainty to the date upon which they will become deductible is inconsistent with some retrospective informal reduction of the period of delay to take account of the acts of the employer if the process has not been specifically authorized and regulated by the contract itself. So notice here also the words retrospective informal reduction, okay, to take into account the acts of the employer. Exactly, I completely agree with this position. It makes perfect sense to me. So with that, thank you very much for your attention, and I'd like to open the floor to any thoughts you may have, and we can discuss this further. Like I said, this is not a scientific lecture or anything. I'm just this is an open discussion for us to discuss this issue. Is there a problem really, or there's no problem? Or so thank you very much. And
thank you, Ali, so much. We have few questions written already. Would you like to start first with this one? So
sure.
Answering them first. I don't know if you have answered some of them, but I think you answered like the first three of Amr. Amjad was asking, he was just actually making a statement. He said, Amjad Sami, he was saying, in my opinion, the provision in the civil code is meant to be addressed the pre-agreed rates, which is constitute the pre-genuine estimate of the losses, which is anchored or will be anchored by the creditor, while the scenario in question is a different matter related to the actual delays. For example, numbers of days, which is maybe in dispute. Is that a reasonable interpretation?
Well, my answer to this is I believe that the law really addresses the scenario that I mentioned in this presentation, not the issue of liquidated damages being a genuine estimate. And actually, the reason is because there's another provision in the Qatari and Egyptian and of course Emirati and other laws that talks about that liquidated damages would not be applicable if they are proven to be grossly exaggerated. So that actually goes into this issue of genuine estimate, but that's not the same provision. And also the reason one of the reasons for this is when I talked to my friend the arbitrator, and we went into lengths about it. He was taking this very lightly, saying, of course, this is something that is normally is very common to be done in any arbitration award. We just, we look at the delays and then we reduce the damages. So this is why I believe that the laws itself in the civil code, the provisions in the civil code address this issue of reducing damages when there's a contribution of delay from the employer.
Thank you, Ali. Another question, how prolongation costs will be calculated if intermediate MS milestones is delayed, but no projects or project completion, but no project completion. This milestone is having penalty if delayed.
Well, I think this touches on another principle, which is, again, in the civil codes, is if you have interim milestone dates and the project completion date is not affected, and here's the important point: the employer did not suffer harm because of a delay in the milestone dates, but will suffer harm if there's a delay in the completion date of the project. In that case, regardless of the prolongation costs, and I don't think actually prolongation, there is no prolongation cost. Actually, if you answer the question, there is no prolongation cost because of delay of a milestone date. The prolongation costs by their nature means the cost associated with a prolonged presence on site. Prolonged presence on site means prolonged over and beyond the completion date of the project. So in a milestone date, the contractor in any case has presence in the project until the project completion date as a whole. But the point I was trying to say is that if the contractor can prove that the employer did not suffer harm or loss because of a delayed milestone date, even if the contractor is 100% delays, then according to the Egyptian Civil Code, and I believe other codes as well, then the liquidated damages on the milestones would not be due.
The issue, I think, in Qatar is that the penalty word is not used actually on the general contracts. It's basically used on the government contracts as only. So nobody is allowed to apply penalties, as per my understanding, but the government, which is basically Ashghal projects and other projects, but liquidated damages on the other projects. So Yusuf is asking about, okay, the delay due to owner should cause an extension of time, thus a contract variation and probably prolongation cost for the contractor. Liquidated damages shouldn't apply on the delay caused by the employer or its parties. Don't you think that the contract should be governed that issue of extension of time, and sanctions should be applied on the parties or the party of fault or not responding on time? It's a little bit complicated.
Yeah, yes, I believe so. But I think what happens really from an industry practice is that sanctions are applied on the contractor. Of course, I'm saying this, and I'm as Saad has mentioned, I work most of my career. I'm working on the employer side, but the truth is that the contracts have provisions for the application of liquidated damages, but they do not have a provision for the failure by the engineer to or the employer to issue a determination on time. And as I mentioned, that definitely affects progress by itself. So yeah, the answer to your question, Yusuf, is that I think yes, the contract should have that, but sadly, in practice, it's not really balanced. There's no consequences for engineer or employer's failure to respond on time.
Okay, perfect. Walid, I would like to ask you specifically on this issue. We have been discussing now the intermediate milestones and the penalties and liquidated damages. I have seen in some contracts here and in the region that some of these intermediate milestones already has a penalties for delays. On the same time, when it gets delayed, the contractor is actually providing like prolongation costs if they got an EOT for this specific milestone. The cases I have seen actually was in the mega projects where actually when considering the extension of these milestones, it requires a big amount of, I would say, like a indirect cost supervision. So it will require an existence of bigger number of, I would say, facilities, people, because when you go to mega projects, as you know, it's been, divided into smaller projects, I would say. It's one contract, but it's smaller projects with different milestone intermediate dates. So what do you think about this approach? How we can apply or how we can calculate the prolongation for these? Would it be applicable or?
Yeah, I think the key word in the MENA region laws and something that you just actually in your question you put it in there, is that has to be harm. So there's a cause and effect. So for example, there's an intermediate milestone, and as you mentioned, in mega projects, the result of this extension is that there is going to be a harm or an extension, incurred costs because of, you know, this as a direct result of this extension, which we would say must not be attributable at all to the contractor. It's purely from the employer or an outside source, for example. In that case, then as long as the contractor can prove that, is that there is a resulting, there is this cost component, then yeah, I think that would be contractually and legally compensable. And also, but how to calculate these costs, I would just say, I mean, I'm from the school of thought, whenever, say, I have a prolongation cost claim, I'm not in favor of, like, you know, okay, so we have a, you know, 60,000 pounds per day, for example. No, you need to prove from the records what are the costs that have been actually incurred, because, you know, in the first half of the project, for example, your forecast of what the prolongation cost is going to be is different than when you're at the last third of the project, and so it makes a difference. So that's my answer to that.
Which is actually leading to the next question, is asking about. Okay, just let me open the question again. Sorry, missed it. Which is more strength on the application of LDs? Is it the SCL protocol or AACE recommended practices? Which one you recommend to the follow in large EPC projects?
I can't see this question.
It's on the chat. It's not in
on the chat.
Yeah.
Okay, so on the chat. Which is more stringent on the application of LDs? Is it SCL protocol or AACRP? Actually, I don't think either is contingent, is stringent on the application of LDs. I think that both are they underline this issue of concurrent delays, of pacing delays, of all this. So if anything, they are both, I think, very, very balanced. Which one do I recommend to follow? That's a very tricky question because this is an AACE event. But one thing to bear in mind is that the SCL is like a general document. It's intended not to be a very detailed document. If you look at AACE, and if you actually attend the webinar tomorrow, inshallah, you'll find that they have several recommended practices. The one that I mentioned in this presentation, the 29R-03, is a very, very detailed technical document. You can't really, it is compared to the SCL, but when you look at it, it's not really, it's something of a very highly technical nature. So what I would recommend is that if the reader wants to have a general idea on the principles of concurrent delay, of the principles of, you know, like what are the different delay analysis methods, the SCL would be a good approach. But if someone like a planner or a contracts person wants to know the nitty-gritty details of how to really implement a certain method and what are the caveats of the methods and all this, then the AACE would be actually the better approach, I believe.
Can I add also, Walid, that there is nothing actually could be better than the others, because basically all of these are like guidelines or best practices, which is like at the end of the day, it gives you the general understanding and guidelines for you to make your research and make your implementation more. So basically, despite if you're using SCL protocol or AACE, the most important thing for the reader or the guy who will be receiving your analysis is to be convinced and based on solid basis. This is what is going to be happening if you do not use any of the practices. The most important.
But the one thing that is actually very interesting in both, which actually Bordeaux is very perplexing to me, is that neither of them refers to any case law. So although your question about liquidated damages, or this is actually legal, and we we are really engineers, and AACE is predominantly it's for cost engineering, as I mentioned, so it's predominantly an engineering thing. They intentionally do not refer to any US case law in the RP for the 29 R-03. The SCL mentions also that there is no case law, although they took into consideration English case law, but they did not. The document does not, have specific references to case law. Yeah. So again, you can. It's not. It's. They're both documents that cannot be relied upon solely for say legal decisions. They're just purely, as Saad mentioned, they're guidelines, and you can say they're, for us as engineers, they're industry guidelines of international practice.
Yeah. One last question from Mohammed Hindi. He speaks about LDs is 5% as per law or only common and can increase it. I don't know if you have mentioned this 5%, Walid.
I did not. This is in the Q&A, or I cannot. LDs is 5% as per law only, common and can increase it. I don't recall that the LDs is 5%. I think Mohammed mentions maybe I think what he's saying when you say per law, liquidated damages as a percentage in Egyptian law is mentioned in the law of tenders, law 182. قانون المناقصات. Before it was 98, but now it's the I think it's not مزايدات والمناقصات anymore. It's not tenders law anymore. It's something else. I forgot the name. But they have provisions, yes, for liquidated damages percentage, and it has the but remember that law is only for public projects, not for private projects. The civil code does not have, as I recall, in the construction part of it, does not have anything about liquidated damages percentage.
I think Walid is mixing between the liquidated damages and interest rate. So in UAE previously the court was awarding 9% and they reduced it recently to 5%. This is in UAE. So this is the percentage where the interest rate is applied in UAE. Of course, each country has its own, I would say, best practice regulations or rules by the courts and stuff like that. UK.
Yeah, I think as you mentioned, actually, right now the keyword is best practice. So it's just a guideline. It's just a practice. Actually, like right now, there's a note by Raj Kumar saying that it is generally 10%. I would underline the word generally. So generally, best practice. It's not really set in stone. It's not. So it can be 15, it can be 20. I mean, of course, we're talking about the limit. But
maybe it talks about the maximum that could be applied by the court in several jurisdictions. Maybe this is what he needs to ask about.
But let's not forget that whatever the value is, and I'm not in favor, actually, personally, of this percentage figure, because let's remember that liquidated damages, by definition, mean the damages that are genuinely estimated at the time of entry into the contract as to what the employer will suffer if the product is not completed by a certain time. So that should be fairly accurately calculated, and the employer should actually have these calculations, because if as we mentioned before, if it is proven later on these are grossly exaggerated, these damages, then by civil law, and even by even US law or UK law, if the damages are proven to have been say in a penalty, or they're grossly exaggerated, then they could be reduced. So the issue is not the percentages or what's common. Does it really reflect the damages that will be suffered?
Yeah, he added a note later, and he said he was speaking about the LDs because his contract is fixed as percentage 5%. That's why he's asking. I think the LDs also in some jurisdictions, Walid, in MENA region, especially GCC, has a caveat of like 10%. This is the maximum could be applied from the employers before going actually to the court. Like they can apply up to, I think, 10%. Then if there is dispute, it will move to the court. And if it's an LDs, it has a different calculation, as you said, where the court will be deciding if to increase it or decrease it. And if it's penalties, I don't think this term is used in some of the GCC countries, but it's still used in Qatar, for example. The term is penalty, where the government firms can apply penalties on the delay projects. They can also have a certain percentages, but it's for contract drafter to do it. So I think this was the. Walid, would you like to add something before we?
Oh no, thank you very much, Saad. I really want to. I just want to thank you for this opportunity and this collaboration.
Thank you so much. So Walid, thank you so much for this one. We had like 5-6 questions more. You are more than welcome to contact Dr. Walid through LinkedIn or by sending him an email asking questions. We will be sending you, gents, ladies and gents, of course, this presentation and the attendance certificate. We were in delay for the past few months for sending these ones. You know that it's a voluntary work, so some of our teams will got busy to be assigned to do this one. So bear with us, and you will receive it, inshallah. Thanks again, Walid, for this informative session. This is not the first cooperation, and inshallah, it's not going to be the last cooperation as usual. And thanks for everyone who attended today and spared the time to come and see us.
Thank you, Saad. Thank you, Qatar section. And thank you, everyone who attended and who's watching this. Thank you very much.
Thank you so much, Walid. Seriously.
Yeah.
Assalamu alaikum.